Well, you see the result in, that's Chief Justice Berger who's hiding behind the horn. You see the result in the Houchins versus KQED case with Berger writing the plurality opinion for himself and for White and Rehnquist, with a dissent by Stevens, joined by Powell and Brennan, and a concurring opinion by Stewart, with Marshall and Blackmun were not participating. So the decision is sort of 3-3-1. And the Chief Justice, in his opinion, resolves both of the ambiguities that have been left in Stewart's opinion in the Pell and Saxby cases. So here's Berger saying, neither the First Amendment nor the 14th Amendment mandates a right of access to government information or sources of information within the government's control. He's not saying you can't come into a jail. He's saying there's no First Amendment right of access to government information or sources of information in the government's control. And second, he says, the media have no special right of access to the Alameda County Jail different from or greater than that accorded the public generally. In other words, the press does not have access to information superior to that of the general public. Those are crushing blows to First Amendment interests, that there is no such thing as a First Amendment right of access to government information, and that in situations where it's not practical for the general public to find out things, the press doesn't have any special access that the general public doesn't have at all. That's sort of a bad news, good news situation. Starting with the bad news, the First Amendment took a real blow in this decision. The good news is that the case was such a weak precedent based on the vote split. It was basically a tie, 3-3, with one opinion, Justice Stewart, getting caught in the middle, and deciding that he agreed with those general principles invoked by the Chief Justice. But he says that if any access is permitted by the jail or by government generally, with regard to the press, because of its special role under the First Amendment, its explicit acknowledgement in the First Amendment that the press has important responsibilities in our democracy, because of its special role, that if access is permitted for the public, then access by the press must be, quote, effective. And he italicizes the word effective. And in the context of the jail, he says that means that the press must be allowed to use the tools of its trade, cameras, recording equipment, and so on, where the general public might not be allowed to, but the press must be allowed to. And that, in the context of the jail, the press must be allowed access at reasonable times, i.e. when something newsworthy is happening, not on some monthly guided tour that has nothing to do with any newsworthy events in the jail. And so Stewart says that if access is permitted at all, then the press must be allowed to do these things. However, consistent with his theory, the press, along with the public, can be excluded from certain areas of the jail altogether, like the Little Greystone part, the maximum security part that was causing all the problems. Because the general public in their tours wasn't allowed to go to that part of the jail, neither would the press be allowed, because that's access to a source of information that the general public didn't have access to. And similarly, the press couldn't interview prisoners because the general public wasn't allowed to interview prisoners. A little bit bizarre. He's saying, on the one hand, the press doesn't have any rights that the general public doesn't have, and on the other hand, he's saying, but the press does have special rights that the public doesn't have, the right to use cameras and so on, the right to come into jail when something is happening. And the result of the case was that it was after, whose phone is that? If it's for me, tell them I'm busy. The result of the case is they remand for further proceedings. It's a standard last line of a Supreme Court decision. We remand the case for further proceedings in light of this opinion. So the case comes back down to the district court, and the sheriff by that time had figured out that these tours were good. They were good public relations. People liked them. The sheriff liked them. And he didn't want to discontinue the tours. They didn't cost hardly anything. So he was going to continue the tours. Well, we then said, under Stewart's concurring opinion, if he allows the press in at all, he must allow us, the press, to use our cameras, recording equipment, and to come in when something newsworthy happened. And the sheriff's lawyer agreed to that, so we settled the case on that basis, with KQED getting much of what it wanted in the way of access to the jail. Not everything, but getting much of it. But losing this terribly important First Amendment principle about access to government information. Justice Stevens dissented in the case. You read his dissent, and you want to agree with it. He says that the official prison policy of concealing knowledge about what goes on in the jail from the public by arbitrarily cutting off the flow of information at its source, which is what the sheriff was doing. Cutting off the flow of information at its source abridges the freedom of speech and of the press, says Stevens. But that did not command a majority. I didn't realize until a few years ago, when a graduate student here at Berkeley brought it to my attention, how close we came to winning this case and winning the First Amendment principle. There was a book called Freedom of the Press, published 10 or 15 years ago now by Bernard Schwartz, and in it he got access to the retired justices' papers, and found there the notes that one of the justices had taken at the conference on which they voted on this case, and learned that the vote on the case was 4-3 in favor of KQED, with the opinion being assigned to Justice Stevens to write the majority opinion. Stewart was one of the four in the majority. And then Stevens circulated his opinion, which must have looked very much like his dissenting opinion in the case, and Stewart got cold feet and sent Stevens a note saying, I regret that I can't join this opinion, creating a First Amendment right of access. And he then agreed, and then he determined that he would write a separate opinion. That converted Berger's dissent into the majority opinion, and Stevens' dissent would have been majority opinion into a dissent. So it's very close, but the precedent stands. Accept it, live with it. There is no First Amendment right of access to government facilities or information. Not quite the end of the story, however, because 2 years after KQED, in 1980, the court decided a series of 4 cases, all involving whether there was a First Amendment right of access to criminal trial proceedings. The first case was the Richmond newspapers case in 1980, in which it was the 4th time that this particular defendant had been tried for murder. It was a murder case, and he had been convicted once and appealed, and the conviction was reversed. He was sent back for retrial. And there had been, I think, 2 mistrials where something had gone wrong in the case, and they had to retry it. So they come up for the 4th trial, and the defendant moved to exclude everyone from the courtroom for fear that spectators were relaying to witnesses in the case information about what other witnesses had testified to on the stand so they could harmonize their testimony. And the defendant wanted the courtroom cleared. The judge looks at the prosecutor, says, you got any objection? The prosecutor says, no. Judge orders everybody out of the courtroom, except, obviously, the lawyers and the defendant, and proceeded to conduct the case with the courtroom closed. No spectators, no press, no public. A couple of reporters for the Richmond newspaper stood up and objected and said, Your Honor, we have a right to be here in this courtroom. And the judge said, no, you don't. And they went and got their lawyer and filed some papers, and the case went to the Supreme Court, with the question being whether there's a First Amendment right to attend a criminal trial. And that seemed to Chief Justice Berger to be an entirely different situation from the KQED case. And Justice Berger writes the opinion in the Richmond newspaper case, holding that there is, too, a First Amendment right of access to criminal trial proceedings. And his reasoning was twofold. That first, there is an unbroken 700-year history of openness of criminal trials in the Anglo-American legal system. Going back deep into medieval England, trials have always been open to the public to come in and observe what's going on there. And Chief Justice Berger for the court determined that that history of openness was sufficient to create a presumption, a legal presumption, that criminal trial proceedings are open. I think I mentioned this when we talked about WikiLeaks, but a few years ago I went to the Independence Hall in Philadelphia, where they wrote the Constitution behind closed doors, in secret. When you walk into the building, you go in here, and you walk into the building, and the closed doors where they wrote the Constitution's over here, and on the right is a perfectly preserved 18th century courtroom, with all of the stuff you expect in a courtroom, where the judge sits, where the defendant would be, where the jury box was, and so on. And to get into the courtroom, there are 3 big arches and no doors at all. So anybody who walks into the building can walk in and see what's going on in the courtroom, or walk into the courtroom. You don't have to knock on the door. You don't need access. There's no way to exclude people from the courtroom. And it struck me when I saw that this is a pretty eloquent architectural statement of Chief Justice Berger's point, that in our tradition, courtrooms have always been open for the people to see what's going on there. But the history alone was not sufficient to create a First Amendment right of access to criminal trial proceedings. Rather, Chief Justice Berger looked to some functional values, some practical considerations, some utilitarian points. And the question is whether, as a practical matter, openness helps the integrity of the trial process itself. And Chief Justice Berger pointed to 3 functional values that were served by openness. One of them is that it gives the public the assurance that trials are conducted fairly. For example, if they're open, everybody can see what's going on. That discourages perjury. People might find out that somebody lied in court. Openness discourages bias in the conduct of trial proceedings by both the judge and the prosecutor. And then secondly, the openness serves the practical purpose of contributing to public acceptance of the criminal justice system. When they can see what's going on and they are educated by what they see, they accept our way of resolving serious disputes in our community through law rather than by revenge or self-help of that kind, and encourages public support of the rule of law. And third, openness has a kind of therapeutic value. Chief Justice Berger called it a cathartic value, in that the people can see that justice is being done, and it's an outlet for community concern. So the court ends up holding in the Richmond newspapers case that there is a First Amendment right of access to criminal trial proceedings. Justice Stevens wrote a concurring opinion saying this is a real watershed. We finally recognize a First Amendment right of access to what the government is doing, limited though it is to criminal trial proceedings, and we should have done that in KQED 2 years before, Stevens says. Berger didn't appear to think KQED was relevant. He never mentioned it in the Richmond newspapers case. And then following Richmond newspapers, the 3 other cases in the 1980s, the Globe newspaper case was one involving a Massachusetts law which required judges to clear the courtroom in a case where a minor victim of crime would be testifying. and the Globe newspapers from Boston challenged that law, and the Supreme Court, using the reasoning of Richmond newspapers, threw out that law as unconstitutional. The court was sympathetic with the need occasionally to protect the sensibilities of minor crime victims, but pointed out that this law applied across the board to all cases involving minor victims of crime, and there may be no need in many cases, maybe even most cases, to make any special arrangements for them to testify and so on, so that the law was clumsy, overbroad, not narrowly tailored to deal with any specific problems, and therefore the law was invalid. And then the next case, just 2 years later than that, the press enterprise case from down in Riverside County, involved a death penalty prosecution, and for the examination of prospective jurors in the trial, it's a process called voir dire, from the French, where the jurors are sworn to tell the truth, and the prospective jurors are, and then asked about whether they know any of the parties in the case, whether they know anything about the case, they've read about it in the newspaper, seen it on television, have views on the death penalty or on crime and punishment in general that would interfere with there being fair and impartial jurors, and so on. And that's the voir dire process, and the judge found that jurors were somewhat reluctant to speak in front of a courtroom of people about their closely held views, and so the judge ordered the courtroom cleared. No press, no public. And that went to the Supreme Court. And in that case, the court said that the reasoning of Richmond newspapers applies again. The history showed that prospective jurors had not been excluded. The spectators had not been excluded during the examination of prospective jurors historically. And in terms of the utilitarian value served by openness of the voir dire process, the court pointed out that all of the same factors apply. You want to know who the people are in the community who are serving on juries. On juries, you see that they're just folks like us. That has an educative value, that has a therapeutic value, and it assures people that the whole process is fair. So the court overturned the order clearing the courtroom. And then the second press enterprise case, in a different death penalty case, where the court cleared the courtroom during the preliminary hearing. It was a serial murder situation in Riverside County, serious death penalty case, and the court thought that the publicity that would be generated by having the press report the testimony in the preliminary hearing, trying to figure out whether there was enough evidence to subject the defendant to trial, that publicity might contaminate the jury when and if the case would actually go to trial. So he cleared the courtroom, and the case went to the Supreme Court. And once again, the court says, no, you can't do that. You can't shut the courtroom down. Here, the historical evidence was spotty at best, because going back in history, they didn't have preliminary hearings. It was an invention, basically, of the 20th century. But they had been fairly consistently open ever since they started. So there was some historical evidence of openness. But the court, then looking to the utilitarian values, the practical values of openness, said, well, in most cases, there is no trial. And a preliminary hearing will be the only chance for the public to hear actual evidence in the case. Because after a preliminary hearing, frequently there's a plea of guilty to some charge, and the case might even be dismissed on preliminary hearing. And the public would never learn what the evidence would have shown. So since this is the only game in town, this should certainly be available to the public so they can see what's going on. So the result, again, in the press enterprise case, the second press enterprise case, was the same. That was 1986. That's the last time the court has spoken on this issue. I don't mean this issue of access to criminal trial proceedings, I mean this access issue. With K2ED on no general First Amendment right of access, and then we have the Richmond newspapers line of cases which say, but there is a First Amendment right of access to criminal trial proceedings, and the court has never gone beyond that. The California Supreme Court a few years ago did go beyond it to civil cases in a notorious Clint Eastwood palimony kind of case where he and his former lover were locked in litigation over some movie rights, and it was a Hollywood type scene with the tabloid media wanting to report every gossipy item that came out, and the judge got fed up with that and closed down the part of the civil case that wasn't conducted before the jury. He would allow spectators, including the press, in to watch what the jury could see, but when the jury was excluded from the courtroom, the judge cleared the courtroom of the press and public. And all sorts of things were discussed without the jury there. Various kinds of evidence that might or might not be admissible, what instructions would be given to the jury, and so on. And the California Supreme Court said that the judge can't do that, even in a civil case, and relied in its reasoning in the NBC subsidiary case on Richmond newspapers. Said the analysis of Richmond newspapers is what governs here. Historically, civil trials have been open to the press and public. That unbroken, centuries-long openness creates a presumption of openness, and the practical values of openness, the same ones that apply in the criminal context, are pretty much similar considerations in the civil context apply, so that there is a right of press and public. Press not getting any superior rights to trial proceedings. I mean, you'll see if you go to a courtroom that the press gets access in ways that the public doesn't.